Concerning and coming to the ninth category of circumstantial proof for a common criminal plan, the prosecution relies on what it believes to be the Duterte's administration's unabashed publication of statistics recording the number of deaths occasioned in the context of the so-called war on drugs. But let us just look at how and where the statistics relied upon were being published. In two government reports, the first of which being the Duterte administration's year-end report for 2017, totaling 63 pages, covering every sector of government and the economy, and of which just 2 pages are devoted to policing activities. We can give you the document ID number shortly. It's on the screen. While the deaths of 3,967 drug personalities mentioned are indeed recorded, as Ms. Robin Croft so helpfully pointed out in her presentation, and are not insubstantial, these deaths comprise a fraction of the 118,287 total arrests for drug-related activities, especially when the government is conducting special operations in a concerted drive to curb the narcotics problem. Such statistics are certainly not indicative of a wholesale policy of murder designed to supplant the process of law. If they were, then certain Latin American state parties would have regularly equaled or exceeded the Philippines in the number of law enforcement killings per capita of the population. What is quite egregious, however, regarding the prosecution's reliance on the 2017 Key Achievement Report is the way in which it glosses over, or rather ignores, those pages which do not suit its case theory. Take, for example, pages 28 of the document, which highlights the fact that 1,900 drug-related investigations had been carried out against law enforcement officers in the preceding year, with 375 police officers being dismissed, including the 2 policemen involved in the murder of Carl Arnaiz, who were later convicted and sentenced to life imprisonment. These policemen were affiliated with the Caloocan City Police Station, and where, so the report mentions, 1,000 personnel belonging to that station were sent for retraining. To conclude, this document, far from being evidence of a conspiracy hatched between co-perpetrators, is in fact a testament to the Duterte administration's respect for the rule of law and written proof of its intolerance for rotten apple police officers. As for the second official publication, which is supposed to substantiate the criminal plan, we turn to the 2016 annual report issued by the Philippine National Police. The statistics are quoted, with all respect, in a misleading fashion. The tables used by De La Rosa, and particularly the pie chart, show a remarkably low incidence of deaths in comparison to arrests and voluntary surrenders. Obviously, the misleading aspect of that is the prosecution's representation of the statistics, not De La Rosa's. So, coming to the 10th and final source of circumstantial evidence, supposedly supporting the mutually agreed nature of the criminal plan. And this is the fact that the extrajudicial killings, to quote the prosecution's words, followed the same patterns and modus operandi, with the perpetrators covering their tracks. But here, let me ask a question which begs an answer. If the Duterte administration was so barefaced as to openly declare its intent to kill drug users and pushers and celebrate this, as the prosecution argues, in official governmental publications, why would it encourage the perpetrators to go to such lengths to disguise such an intent? I mean, of course, anything's possible. But I'm just pointing out the internal contradiction in the prosecution's case theory. In any event, as they say in English, there is more than one way to skin a cat. And the differing types of modus operandi that we have encountered in the prosecution's 49 incidents of murder involve all conceivable modes of butchery, ranging from strangulation, suffocation, to stabbing and shooting. Now, assuming that the prosecution can overcome the hurdle of proving the existence of a common criminal plan, how has it shown that the so-called co-perpetrators coordinated between themselves to reach a mutual agreement to execute it? Well, it hasn't. All it can do is show a selection of comments made by Mr. Duterte's closest colleagues in government, and all of which take their rhetorical cue from him. The prosecution then artificially defines the intended individuals, the identified individuals, as a collective of co-perpetrators. Now, common law jurisdictions, such as the one I come from, are familiar with these issues in the context of the law of conspiracy. The federal rules in the United States, for example, allow the statements of co-perpetrators to be used as circumstantial evidence, one against the other, to establish the existence of a conspiracy, but require that these statements be made during and in furtherance thereof. Narrative venting, which is what all these supposed co-perpetrators did, the ones identified by the prosecution, does not further the criminal objective. In furtherance thereof means that the statement relied on must advance the objectives of the conspiracy, such as through reassurances, updates, or actions taken to avoid detection. Now, I do realize, Your Honours, that there isn't too much jurisprudence on this matter, but let us look at it logically. Where can one really draw the line if it is sufficient to infer a mutual agreement to execute a criminal plan if we rely only on the statements of the people in the vicinity of a criminally verbose suspect because of the same quality of verbosity it alleges? This is what could be called bootstrapping logic, building on limited information with the very same information in an attempt to validate that information or to create a structure there without. Put simply, the prosecution has advanced its cart before its horse. It has merely selected a number of individuals working alongside the former president who made similarly offensive comments and has then called them co-perpetrators. Instead of seeking evidence which might shed light on the interactions of these individuals between one and another, and construing a criminal conspiracy therefrom, should the evidence even support such a hypothesis, the prosecution has taken its preconceived and predetermined premise of a criminal plan and forcibly superimposed it on these individuals. The artifice of the prosecution's working methodology in conjuring up this criminal collusion becomes even more apparent if we examine the evidence emanating from the crime-based perpetrators themselves on a granular level, especially from the prosecution's own star witnesses, three of whom supposedly formed the hardcore of a more limited organisation referred to earlier in my submissions. I'm trying to comply with redactions. P1, for example, a self-confessed murderer whose recruitment by the prosecution will be examined elsewhere, was asked about the common criminal plan of his associates up to 2017. And this is what he had to say. Every time somebody was at fault against the government of Rodrigo Duterte, we didn't bother to send them to prison. We would just kill them. That's PHL OTP 0001 2584 at lines 248 to 250. Okay, and that was the audio which I just quoted, and here we have the transcript. PHL OTP 0001 2376 hyphen R02, lines 248 to 250. So, having given you that quote from P1, I would say that as far as this witness was concerned, the common plan was not a refined policy of cleaning up the streets, but rather a killing frenzy of the political opposition. Obviously, no such policy existed, and no such policy is alleged. P3, whose evidence relates to the presidential period, describes a similar orgy of killing without rhyme and without reason, but not drug addicts, nor alleged criminals, but rather was so petrified of not meeting this quota of slaughter that he was randomly grabbing and killing just so that there would be something to report on TV for the one-time, big-time operation. Now, I ask you, how can P3 have been operating under a clear criminal direction to target drug users for murder, criminals for murder, when he states that on occasion he would perform so-called clean arrests? It's the prosecution's witness, P3. He's not clear when he's actually following their supposed criminal theory or when he is. What are clean arrests? These are arrests subsequent to which the apprehended criminal would be handed over for a judicial process. And so with that I believe I have exhausted the first limb of the objective requirement for indirect co-perpetration and have shown conclusively that there was no mutually agreed common criminal plan. Madam President, there are 10 minutes to go. I will start with the concept of essential contribution, which is indeed the second limb that I want to talk about with respect to this mode of liability, which requires the prosecution to show objectively that Mr. Duterte himself made an essential contribution to the furtherance of this scheme of criminality, and what is more, that subjectively he was aware that he was making such a contribution. This is what us Latin-speaking lawyers, would call the sine qua non test. Or to put it another way, did these 49 murders, which the prosecution has identified, occur specifically because of Rodrigo Duterte's involvement? Or, to make the logic a whole lot simpler, would Rodrigo Duterte's withdrawal from this criminal scheme to target suspected criminals, as alleged by the prosecution, have led to the avoidance of these 78 deaths? Let us see where this test is set out in the Ali Koshaib trial judgment. Paragraph 796. And I'm going to quote the essential part for the purpose of the essential contribution. The accused must make an essential contribution without which the commission of the offence would not be possible. To hold an accused liable as a co-perpetrator under Article 25(3)(a) of the statute, it has to be established inter alia that he or she had control over the crime by virtue of his or her essential contribution to it and the resulting power to frustrate its commission. Well, here I would like to show you the statistics pertaining to the rate of killings since the former president has left power and the responsibility for law and order has passed into the hands of President Ferdinand Marcos Jr. I rely on a report published by academics at the Third World Studies Center in the University of the Philippines in the context of what is called the Dahas Project. And trust me, the authors of this report, comprising weekly statistics on the first year of the Marcos administration from 2022 to 2023, are no great friends of the former president, Mr. Duterte. This report was even cited, I remember, in a Rappler article, but it's to be found on our list of evidence at PHL D36 0006-0001, pages 0006 to 0010. The report for the first year of the Marcos administration showed that out of 342 killings, 160 were at the hands of state agents. And the figures and the statistics just kept on rising, with the second year of the Marcos administration, 2023 to 2024, showing an increase in deaths at the hands of vigilantes, albeit a decrease in deaths at the hands of law enforcement officers, from 46.8% to 34%, hardly a statistic to be proud of. So, with all the prosecutions, fancy bar charts, I'm pretty sure that if they were to recreate them for the period of 2 years after Duterte left power, they wouldn't have room left on their computer screen. The numbers would be so sky high. The conclusion is that there is no reason to believe that Duterte's disappearance from the political scene would have frustrated the ongoing incidents of murder at the hands of state agents or vigilantes. Clearly, I'm forced to ask myself whether anyone on the other side of this room has thought of investigating the Marcos regime and the related phenomenon and holding someone accountable. Why are my colleagues sitting to their right, the victims' representatives, not clamoring for accountability for those deaths? Or is it of no consequence now that Mr. Duterte is sitting in the ICC detention center? I've reached a natural break, Madam President, in my submission. With your permission, I would like to continue after lunch.
Judge Motok. Thank you very much, Mr. Kaufman. We will suspend the hearing now for 90 minutes to resume at 2 p.m. Thank you very much.